you're a Florida parent and you know you need an estate plan, but you're not sure what should actually be in it, that confusion is probably the reason you keep putting it off. And I don't want that for you, because the longer you wait, the longer your family is unprotected. So in this video, I'm going to walk you through every document and every decision that belongs in a complete Florida estate plan, so you finally know exactly what you need and nothing gets missed. Hi, I'm Stephanie Padley-Julian, founder of Padley Law. And as a mom myself, I understand how important it is to protect your children, your home, and your legacy. For over 15 years, I've helped families across Florida create personalized estate plans that give them the peace of mind they deserve, knowing their loved ones are cared for no matter what. If you're ready to protect your family's future, I'm here to help. Call us today at 239-963-6043. Let me start with the document most people think of first, and that is the will. So a will is your family's starting instructions. It is where you name who you want to raise your kids if you're not here. It is where you name who manages money on behalf of your children, and it gives clear directions on how you want your affairs handled. Now here's what a lot of families don't realize. A will does not avoid probate in Florida. It actually goes through probate, which is a court process. But that does not mean a will is not important. Without one, you're not just leaving things to chance. You are handing every decision over to the state of Florida. The state decides who raises your children, the state decides who manages your money, and the state follows a formula that may not match what you would have chosen at all. Think of your will as the document that makes sure your voice is heard even when you're not here to speak for yourself. And if you have young kids, this is where you name guardians, which alone makes this one of the most important things you will ever sign. A small tip here is to also write a care letter to go alongside your will. It's not a legal document, but it is a letter to your chosen guardian that explains your children's routines, values, important relationships, allergies, school details, and what helps them feel safe. It turns a legal plan into a personal one, and it can make a huge difference for your children during a difficult transition. But here's the thing, a will only covers what happens after you pass away. It does nothing for your family while you're still alive. And this is where most plans fall short, because the more common emergency is not death. It's something happening to you that leaves you unable to handle things yourself. And that's where the next document comes in. The second document is a durable power of attorney. This is your financial safety net while you're alive. It lets someone you trust step in and handle the financial and legal side of your life if you cannot do it yourself. That means paying your bills, managing your bank accounts, dealing with insurance, handling property issues, and taking care of all the time-sensitive things that do not stop just because you're in the hospital. Without this document, your family may have to go to court and ask a judge for permission before they can touch anything. That process takes time, it costs money, and while it plays out, the mortgage is still due, the kids still need what they need, and everything piles up. As moms, we keep thousands of things running every single day. This document makes sure someone can keep up all that you're doing if you suddenly cannot do it. And the key word here is durable. That means it stays in effect even if you're incapacitated, which is the whole point. A regular power of attorney can lose its power at the exact moment your family needs it the most. So make sure yours says durable. Now, just like your finances need protection, your medical care does too. And the next document makes sure your family is not left standing in a hospital, in a hallway, trying to guess what you would want. The third piece of your plan is a healthcare directive and a living will. These two work together, and they cover one of the most emotional parts of planning. Your healthcare directive or healthcare agent is the person you choose to make medical decisions for you if you cannot communicate. This is the person doctors will turn to when they need answers. Who gets updates, who approves treatments, who speaks on your behalf when you cannot speak for yourself. Now, your living will is different. It spells out what you would want if you are ever in a condition where recovery is not possible and you cannot communicate your wishes. It covers things like end-of-life care, life-prolonging procedures, and comfort measures. These are deeply personal decisions, and your living will makes sure these decisions are made by you and not by someone else under pressure. Without these documents, your family may disagree about what you would want. Doctors may not be able to move quickly, and the people who love you the most are left carrying the weight of a decision they were never given clear guidance on. So these documents are not about giving up hope. They are about giving your family clarity during the hardest moments of their lives so they are not stuck guessing. And that is one of the most loving things you can do for the people closest to you. So at this point, your family's protected if something happens to you. But what about your assets? What about your home, your savings, and everything you have worked so hard to build? So how do you make sure all of that actually gets to the right people without delays, legal fees, or court involvement? That brings us to the next document. The fourth document is a revocable living trust. Now, not every family needs a trust, but for most Florida families, especially if you own a home, this is the most powerful tool in your plan. A revocable living trust is a legal entity that holds your assets while you're alive. You stay in complete control. You can change it, update it, or cancel it at any time. But when something happens to you, everything inside the trust transfers directly to your family without going through probate. So without going to court. That means it's faster, it's private, and it costs your family far less than the court process. Your family can access what they need in weeks or days instead of waiting 6 months, a year, or 36 months. And because it does not go through court, there's no public record of what you owned or who received what. That privacy matters more than most people realize. But here's the part I really want you to hear. A trust only works if it is funded. So that means your assets have to actually be titled in the name of the trust. So your trust either owns the asset or is a beneficiary of the asset. If your home is still in your personal name or your bank accounts were never retitled, those things sit outside of the trust. And when the time comes, they go through probate anyways, even though a trust exists. So creating the trust is step one. Funding it is what makes it work. You work hard to build a life for your family. A trust is what makes sure everything you built gets to them without a court standing in the way in case of incapacity or in case of death. Now, all four of these documents create a strong foundation, but there is one more piece that ties the whole plan together. And without it, even a well-built plan can have holes that no one sees coming. The fifth piece of your plan is your beneficiary designations. Now, this is not a document your attorney drafts for you. These are the forms you fill out when you set up a life insurance policy, a retirement account, or certain types of bank accounts. You write down a name, and that person receives the money directly when you pass away. So here's why this matters so much. Those forms do not follow your will, and they do not follow your trust. They act like their own separate contract. So whoever is listed on that form gets the money no matter what your estate plan documents say. And the problem is that most of us fill out those forms once and never look at them again. But if life changes, you get married, you have kids, and sometimes there's a divorce or a loss in the family. And that old form just sits there with a name on it that may not reflect your life anymore. So when the time comes, the money goes where that form says. And that can be a painful surprise for the people you love. And if a minor child is named directly on one of those forms, the family may need to go through a court process just to get someone legally authorized to manage those funds for the child. So please take the time to pull your beneficiary forms and review them. Make sure the names match your current plan. Make sure backup beneficiaries are listed. And check them again after every major life change, or at least every 1 to 3 years. A new marriage, a new baby, a move, a divorce, that one habit can prevent so much confusion and heartache down the road. So bring this all together. And also, don't forget, you need to have a temporary guardian and a permanent guardian named. Those are essential to keeping your kids out of child protective care, and also with the right guardians you have picked. A complete Florida estate plan is not just one document. It is a will that names guardians and gives your clear direction, in addition to the temporary guardian and permanent guardian paperwork I just mentioned. It is a durable power of attorney that protects finances while you are alive. It is a healthcare directive and living will that makes sure your medical wishes are followed. It is a trust that keeps your family out of court and your assets private. And it is updated beneficiary designations that make sure nothing slips through the cracks. And when all of these pieces work together, your family has real protection. Not just paperwork in a binder, but a plan they can actually use when life gets hard, during incapacity, or during death. So if you're a Florida parent or grandparent, and you've been putting this off because you were not sure what you actually needed, well, now you know. And if you want help putting all these pieces together, call us at 239-963-6043. We'll sit down together, we'll build a plan that fits your family and gives you the peace of mind you deserve. Now, one of the most important decisions inside your estate plan is choosing the right person to actually carry it out. And that choice matters more than most people think. In my next video, I'm going to show you exactly how to choose the right executor for your will or your trustees. Click here to watch it now.